Registration of Article of Association, Section 7 Clause 1 stipulates that during a company's incorporation, company must submit. The beauty of this Section 7(1) is that they use word must, and law basically deals with the interpretation. Basic role of judiciary to interpret the law, and we interpret the law with the permission of words used by legislature. Interpretation is the process to seek ascertain the meaning of legislation in authoritative way what they wants to convey. We draw the conclusion from the word used by legislature. So, legislature here use word must. Must indicate that every company is bound to submit this document to the Registrar of Companies before obtain the certificate of incorporation. That is the precondition. You first draft this document and submit with the Registrar of Companies for obtain the certificate of incorporation. So, this is an essential part of this Section 7(1). Located within the jurisdiction of the proposed registered office, the article signed by all the subscribers in the prescribed manner. So, if we consider one point here, this one second point, this one 3 point, all 3 points indicate that this document is very important document. And how many persons required to sign? Subscribers. Minimum number of persons which we require to establish a company, incorporate a company, those persons known as subscriber, and they sign on each and every document on the behalf of proposed company. Must word indicate you are bound to be frame this document, signed by subscriber, that is the second requirement of statute. Third requirement, in prescribed manner as defined. So, in case of public limited company, we required minimum 7 subscriber. In case of private limited company, we required minimum 2 subscriber. In case of one person company, we required minimum 1 subscriber. In case of producer company, we required minimum 10 subscriber. So, these persons which we required minimum number, they sign on this document. So, this document when signed, it means we presume that they go through in this document, and this document is now become the document of the company. All type of companies, including here public, private, limited by share, limited by guarantee, and with or without share capital or unlimited liability, must register their article of association. Again they use word must. So, must indicate that is the mandatory part. Every type of company who proposed here for or incorporation, those companies frame this document. Section 5 clause 2 states that article must include matters related to additional management and their functioning. How management functioning? For this one, these documents define the condition, powers related to the internal management and what type of functions they perform. And if any time they violate the provision of this document, that amounts to offense, and that's deal according to the provisions of law. According to section 5 subclause 6, company's article should adhere to the specified forms outlined in table F, G, H, I, J. Schedule 1 first 5 tables relates to memorandum of association, next 5 tables relates to article of association, and the specific company deals by this specific table. If a company limited by shares, table F is applicable, or in this same manner, the if company limited by guarantee having the share capital or without share capital, the different table is applicable. Company is unlimited liability company having share capital or not having share capital, different modal form of tables are applicable on those companies. And schedule 1 is the define the tables model forms of article of association and memorandum of association. You may adopt these model forms of memorandum of association and article of association. That is very helpful for those who are not interested to frame their own these documents. So, section 5 subclause 7 permits a company to adopt any or all of the regulation found in modal article. Modal article in previous slide defined here table A, B, C, D, E, these tables relates to memorandum, G, H, I, J, these tables relates to article of association. You may be adopt in full or in part, that is your discretion, there is no problem. Rules and regulations permit either you adopt entire table, either you adopt in part, there is no problem in this regard. Section 5 subclause 8 states that companies registered after the commencement of the Company Act 2013, if their registered articles do not exclude or modify regulation from the modal articles, those regulations will apply to the company as if they were part of the registered article. So, up to that extent, the modal article is applicable on you, which suit to the company, which suit to the policies of the company, policies of the statute. Under section 5(6), a company regardless of being limited by guarantee or having a share capital can adopt suitable regulations from table G, H, I or J. Schedule 1, these tables relates to specific type of companies, that is mentioned which table applicable on which companies. Section 5 subclause 9 clarifies that provision in section 5 do not apply to the articles of company registered under a previous company law unless they have been amended in accordance with the Company Act 2013. If you amended as per this act, then that is applicable. If you registered under previous act, then provision of section 5 do not apply. That is clarify in this section 5 subclause